Hello everyone, welcome to the 225 Literary and Jury Charge. We're going to start off with some literary. This is called the Minimum Wage Law. All right, here we go. You're going to hear Fair Labor Standards Act, interstate, commerce, periodically, customarily, compensation, minimum, previous, occupation, high risk, guidelines, religion, dangerous. All right, you're also going to hear and a half, and the brief for that is NAF. Here we go. Ready? I will read this at 180. The Fair Labor Standards Act specifies a minimum wage for all employers who are engaged in interstate commerce. The minimum age is adjusted periodically to reflect the change in the spending power of the dollar. The Act also sets guidelines for the standard work week of 40 hours. The customary compensation for overtime is time and a half for any hours over the standard. The Act also establishes the minimum age for employees. Depending upon the state, the minimum age is between 15 and 16 years, with special provisions to provide higher minimums for anyone engaged in dangerous or high-risk occupations. In addition to guidelines established by the Fair Labor Standards Acts, most states have established fair employment practice laws of their own. These laws help to prevent discrimination that is based on race, color, sex, or religion. All right. I've got some legal terms and then a paragraph for you. I'm going to read this at 200. Right? You're going to hear opening, direct examination, cross-examination, expunged, irrelevant, overrule, sustain, colloquy, evidence, immaterial, redirect, recross, witness, objections, and perjury. All right, here's your paragraph at 200. The opening statement to the jury is given by each attorney. Direct examination and cross-examination may be followed by redirect examination and recross-examination. Each witness gives testimony under oath. When a witness knowingly gives false testimony under oath, the witness is guilty of perjury. Objections may be raised by either attorney. The judge will either overrule or sustain these objections. The attorney raising the objection may feel that the evidence presented is irrelevant or immaterial. An exchange between the attorneys and the court is referred to as colloquy. Evidence may be expunged from the court record by the judge. All right. Now an excerpt from Don't Sweat the Small Stuff. Develop your compassion. Okay, here we go. I will read this in 180. This is considered literary. Ready? Nothing helps us build our perspective more than developing compassion for others. Compassion is a sympathetic feeling. It involves the willingness to put yourself in someone else's shoes, to take the focus off yourself and to imagine what it's like to be in someone else's predicament, and simultaneously to feel love for that person. It's the recognition that other people's problems, their pain and frustrations, are every bit as real as our own, often far worse. In recognizing this fact and trying to offer some assistance, we open our own hearts and greatly enhance our sense of gratitude. Compassion is something you can develop with practice. It involves two things, intention and action. Intention simply means you remember to open your heart to others. You expand what and who matters from yourself to other people. Action is simply the what you do about it. You might donate a little money or time or both on a regular basis to a cause near your heart, or perhaps you'll offer a beautiful smile and genuine hello to the people you meet on the street. It's not so important what you do, just that you do something. As Mother Teresa reminds us, we cannot do great things on this earth. We can only do small things with great love. Compassion develops your sense of gratitude by taking your attention off all the little things that most of us have learned to take too seriously. When you take time often to reflect on the miracle of life, the miracle that you are even able to read this book, the gift of sight, of love, and all the rest, it can help to remind you that many of the things that you think of as big stuff are really just small stuff that you are turning into big stuff. right. Got some jury charge. And the subject here is Highway Traffic Act. Okay, and you're going to hear prima facie evidence. Okay, that's just based on what it seems to be true before a situation has been examined in detail. All right, I will read this at 200. Ready? Members of the jury, each party in this case charges the other with violating certain statutes of the Highway Traffic Act. It is the law of this state that a violation of any of the provisions of the Highway Traffic Acts by a person operating a motor vehicle upon a highway shall be prima facie evidence of negligence. This presumption of negligence, however, may be rebutted by evidence showing that the statute in question was not violated or by evidence showing a reasonable ground for such violation. The driver of a motor vehicle whose vision is obscured by snow or wind or other atmospheric conditions must exercise care and caution commensurate with the situation. The factors to be considered when determining a driver's negligence are the speed and control of the vehicle, the extent of the visibility, and the degree of care and caution required under the circumstances. It definitely appears that both motorists were driving at a speed lower than the maximum permitted under the Highway Traffic Act, but the fact that the speed of a vehicle is less than that permitted by law does not relieve the driver from the responsibility of reducing speed when special hazards exist with respect to weather, visibility, or highway conditions. It was the duty of each of these drivers to keep his vehicle in his own lane of the pavement. This collision could not have happened if each had done his duty in that respect. It is for you jurors, as judges of the facts, to determine where and how this accident happened and who was to blame, whether both drivers were guilty of negligence, which substantially contributed to cause the accident, or if weather conditions alone were responsible. Should you find that both drivers were guilty of the violation and the violation by each was a proximate cause of the accident, then neither party can avoid liability. Okay. I've got a funny article here. This is an actual article from Housekeeping, the month of May 1955. Now keep in mind, this is an actual article that was posted or published. It's called The Good Wife's Guide. Okay, I'll read this at 180. And it's very interesting. This was in one of the women's magazines in the 1950s. Here we go. The Good Wife's Guide. So this is a guide to be a good wife. Number 1, have dinner ready. Plan ahead, even the night before, to have a delicious meal ready on time for his return. This is a way of letting him know that you have been thinking about him and are concerned about his needs. Most men are hungry when they get home, and the prospect of a good meal is part of the warm welcome needed. Number 2, prepare yourself. Take 15 minutes to rest so you'll be refreshed when he arrives. Touch up your makeup, put a ribbon in your hair, and be fresh looking. He has just been with a lot of work-weary people. Number 3, be a little gay and a little more interesting for him. His boring day may need a lift, and one of your duties is to provide it. Number 4, clear away the clutter. Make one last trip through the main part of the house just before your husband arrives. Run a dust cloth over the tables. Number 5, during the cooler months of the year, you should prepare and light a fire for him to unwind by. Your husband will feel he has reached a haven of rest and order, and it will give you a lift too. After all, catering to his comfort will provide you with immense personal satisfaction. Number 6, minimize all noise. At the time of his arrival, eliminate all noise of the washer, dryer, or vacuum. Encourage the children to be quiet. Number 7, be happy to see him. Number 8, greet him with a warm smile and show sincerity in your desire to please him. Number 9, listen to him. You may have a dozen important things to tell him, but the moment of his arrival is not the time. Let him talk first. Remember, his topics of conversation are more important than yours. Number 10, don't greet him with complaints and problems. Number 11, don't complain if he's late for dinner or even if he stays out all night. Count this as minor compared to what he might have gone through at work. Number 12, make him comfortable. Have him lean back in a comfortable chair or lie him down in the bedroom. Have a cool or warm drink ready for him. Number 13, arrange his pillow and offer to take off his shoes. Speak in a low, soothing, and pleasant voice. Number 14, don't ask him questions about his actions or question his judgment or integrity. Remember, he is the master of the house and as such will always exercise his will with fairness and truthfulness. You have no right to question him. Number 15, a good wife always knows her place. I just thought that was interesting. That's actually from Housekeeping magazine. All right. Moving right along. We're going to switch back to another jury charge. How are we doing on time? Okay, the subject here is interpretation of state law. So you're going to hear constitutionality, authoritative, adjudications, constitutionally. I think that's about it. Inappropriate, Louisiana, state court. All right. Here we go. I will read this at 200. I agree that the state action was properly enjoined, and so I concur in the opinion of the court to that extent, but I disagree and dissent from the direction to the district court to hold the case while the parties repair to the state court to get an interpretation of the Louisiana statute around which this litigation turns. That procedure is advisable where private parties question the constitutionality of a state statute. An authoritative construction of the state law may avoid the constitutional issue or put it in new perspective. Under Section 1331, the federal district court has jurisdiction over the matter in controversy where it exceeds the jurisdictional amount and arises under the Constitution, laws, or treaties of the United States. In litigation in the federal courts under that statute, the necessity of construing the state law arises because of the federal court's duty to avoid, if possible, a federal constitutional question. Here, although potential constitutional questions may lurk in the background, this litigation primarily concerns title to land claimed by the United States. It is litigation which Congress, by sections 1345 and 1346, has entrusted to the federal district court. Those actions and sections allow civil litigation of the United States to be conducted in the federal courts. In that situation, it is the duty of the federal court to decide all issues in the case, those turning on state law as well as those turning on federal law. In Raymond versus Clark, a case in the federal courts, by reason of diversity of citizenship, we refused to remit the parties to the state court for a decision of difficult state law questions. We held that it was the duty of the federal court to decide all issues in the case, state or federal, difficult or easy. There have been exceptions to this policy, notably in bankruptcy proceedings where trustees are sometimes sent into state courts to obtain adjudications on law, local law questions pertinent to the administration of the bankrupt's estate. It is inappropriate to follow that course here. Congress has decided that the United States should have been the benefit and have the benefit of the protection of its own courts in this type of litigation. We properly hold that the federal court, not the state court, has jurisdiction over the controversy, but we beat the devil around the bush when, having taken the litigation out of the state court, we send the parties back to the state court for its construction of Louisiana law, which is the most significant issue in the case. The problem is not only to construe the state statute, but to construe it constitutionally. The federal court can make that construction as readily as the state court. That is the congressional scheme, and we should not change it by judicial fiat. And fiat is just an official order from a person or a group in authority. All right. I have an article here from the Grizzly magazine of the of the California National Guard Leadership Corner. Okay. All right. Here we go. I will read this at 180. After more than a decade deploying soldiers and airmen at a feverish pace and combat operations overseas, we now have fewer than 500 CNG troops in Afghanistan and Kuwait, and none in Iraq. It might seem we should breathe a collective sigh of relief as we return home and take off our boots, but now is not the time to relax. For almost 165 years, the Cal Guard has protected this state from anyone or anything that threatens our communities, and in recent decades, that has meant supporting firefighting operations on a near annual basis. Fire season is now upon us once again, but this year is different. The 2016 wildfire season never really ended. California has experienced a crippling drought throughout the past several months, which has kept our interagency partners busy fighting wildland fires throughout the normally tame winter. Through April 12th of this year, the California Department of Forestry and Fire Protection, CAL FIRE, had responded to 953 fires that had burned 2,372 acres. Both of those figures are more than double the average for the same period during the past 5 years. Dry conditions mean the fuel for fires, leaves, branches, needles, dead plants, and anything else that burns, sparks easily and burn quickly, spreading wildfires at a rapid pace. CAL FIRE has already increased its staff in anticipation of a busy fall, and that means they will likely lean on us for help as well. Last year, our soldiers and airmen dropped more than 1.5 million gallons of water and fire retardant from planes and helicopters, provided medical evacuation support, established satellite communications, and for the first time used a remotely piloted aircraft to relay real-time video of a wildfire and the crews fighting it. We also stand ready to bring bulldozers, heavy vehicles, and thousands of hand crews to the fight to aid CAL FIRE, the State Office of Emergency Services, and the U.S. Fire Forest Service. If your unit has not been called up for fire duty in previous years, now is no time for complacency. Every California National Guard member must be poised and ready to deploy for emergency state active duty on a moment's notice. Now is the time to ensure you are physically fit, tend to any paperwork needed to enable activation, and plan with your family and employer for the possibility of emergency duty. If you live in an area that may be threatened by wildfires, you should also craft an evacuation plan and create defensible space around your home. And all Guard members should stay apprised of wildfire-related news and statewide fire risk. Our organization's number one responsibility is to rapidly respond to state emergencies with a robust, coordinated force that has prepared for the situation it faces. This vital mission is what makes the National Guard unique among all other armed forces components. As the need for overseas deployments have slowed, our commanders throughout the state have refocused their efforts on preparing for domestic emergencies and coordinating with partners at every level of government. As it is in combat, readiness is central to the defense support of civil authorities, known as DSCA mission, and I expect an exceptional level of mission readiness from Joint Force Headquarters down to each company and squadron. All units must devote increased times, training, and resources to prepare for domestic events and ensure our emergency response skills are sharp. Our soldiers and airmen have proven themselves time and again in combat operations overseas, but the defining characteristic of the National Guard is our domestic response capability. The National Guard is the defender of our homeland, just as it has been since 1636. That commitment to our communities is the reason many of us join the Guard, and those of us who are called up for fire duty consider it a privilege to directly serve the people who depend upon us in our home communities. The DSCA mission is also central to the way ahead for the California National Guard. More than any other state, California is ripe with potential for natural and man-made emergencies, and the federal government is increasingly leaning on the Guard to shore up our nation's civil response network. We must embrace these opportunities for domestic missions as our country moves toward times of peace. The effort to prepare for domestic disasters is no less a fight than combining and combating terror and tyranny abroad. Let us approach the upcoming fire season with the same vigor we would with any other enemy. All right. And looks like we're out of time. So that concludes our literary and jury charge for the 225 class.